that time runs, I'm not sure you're talking about an extension anymore.
Okay.
There's ex post facto law that kind of does this
Got
stuff.
it. Thank you.
Can I take you back, Mr. Fisher? Let's say I agree with you that if you're talking about content manipulation, that's an inherently content-based rationale for acting. So if Congress had passed a law that says we hate the content manipulation that TikTok is doing, that's strict scrutiny land, and I don't know that the government can do that, however important and the interest. But that's not what Congress is doing here, and this is the same kinds of questions that I asked Mr. Francisco, because if let's take it as a given that Congress actually can do whatever it wants with respect to a wholly foreign corporation or a foreign government. Yeah. And so Congress could act with the intent to interfere with the content manipulation that a foreign corporation is doing. And so now we're in this strange world where we're saying they can't act with respect to TikTok. They could act with respect to ByteDance. Why isn't this Congress acting with respect to ByteDance in the sense that all it's doing is saying ByteDance has to divest, and then TikTok can go about its business, use whatever algorithm it wants, use whatever content moderation policies it wants, just like everybody else does, choosing from everything that's available on the open market?
So let me answer that question in two parts, from the perspective of the creator Americans who want to use this platform to speak to other Americans. So the first thing is what the act does, as you said, Justice Kagan, is prevent us from working with a application that is owned by ByteDance that uses this algorithm. Well, that's exactly what we want to do. That's our editor and publisher of choice that we think best disseminates our speech.
Yeah, but what I'm saying to you is if you just assume a world without TikTok, where it's only ByteDance, and you were trying to say, well, we really want to work with ByteDance, and Congress was saying, we think ByteDance presents national security interests, and they don't have First Amendment rights. They're just a foreign corporation. I think that in that case, the government, tell me if you think this is wrong. It just doesn't matter that you have creators who want to work with ByteDance, because ByteDance is a foreign corporation with no First Amendment rights. Is that what you're contesting?
So that is what I'm contesting. So you said two things, though, so I could be clear. There's two aspects. Do we have a First Amendment right to work with a foreign company or even a foreign country to publish our speech? And then there's a national security part that you put into that, which goes to the justification.
Forget that.
Forget that, yes. Let's do that. So if that is right, Justice Kagan, then American creators have no right to make documentaries with the BBC. They can't work with Al Jazeera if Congress wants to prevent that. Any number of other publications that are state-owned wholly or partially. And even under Lamont, remember, where you're not even creating speech, you're just listening. That was speech from China that the court said you have a First Amendment right to receive.
So would I be right to say that your position is that because of the users who want to associate and want to partner with this foreign corporation, the foreign corporation ends up having, in your view, the exact same First Amendment rights as your users do? In other words, it's irrelevant that the foreign corporation doesn't have First Amendment rights.
I don't think it's irrelevant, because you could imagine a situation where no American distributor or speaker wants to work with that. But let me put it to you this way. The Communist Manifesto, written by Karl Marx, has no First Amendment standing on its own in America. But if a bookstore wants to sell that publication, I don't think Congress can prevent it from doing so.
Well, sorry. Go ahead.
No, I'm fine.
No.
I'm good.
Okay.